We're now going into our second panel of the day, and I'm just going to give a short introduction to everybody before we get started. Professor Adam Thierer is a senior research fellow with the Technology Policy Program at the Mercatus Center at George Mason University. He specializes in technology, media, internet, and free speech policies, with a particular focus on privacy and safety implications in emerging technologies. Adam has spent 25 years covering tech policy and has authored, edited 8 books on topics ranging from media regulation and child safety issues to the role of federalism in high technology markets. His latest book is Permissionless Innovation, the continuing case for comprehensive technological freedom. Mr. Peter Jensen-Haxel is a patent attorney from the Bay Area. He drafts strategic patent portfolios for venture-backed companies innovating in emerging technologies such as 3D printing and blockchain 2.0. Peter holds a degree in physical biochemistry from the University of California at Santa Barbara and a law degree from Golden Gate University, where he authored the first law review article on 3D printed firearms. After managing patent portfolios for a while, he left to start his own practice and to co-found the cybersecurity startup Mode OS. He's also an avid inventor, and Peter has a passion for working with entrepreneurs and has been a member of the Bay Area Tech Shop Makerspace since its first location in Menlo Park. Mr. Kyle Langvardt is an associate professor at the University of Detroit Mercy Law School. He has recently written on the First Amendment treatment of computer code and its implications for 3D printing, synthetic biology, cryptocurrencies, and other up-and-coming technologies. Today, he will discuss the merits of extending constitutional protections to 3D printing. And our moderator today is Professor Ralph Hall. He's a professor at the law school here at the University of Minnesota Law, where he teaches FDA law, is MJLST's faculty advisor, and is of counsel to Faegre Baker Daniels. He counsels clients in the matter of drug and medical device regulation and corporate compliance matters. He also serves as CEO of MR3 Medical LLC, a startup medical device company, and is a frequent speaker on FDA regulatory issues and compliance matters, and has also testified a number of times before congressional committees. Without further ado, let's please welcome our panelists for our second panel. Thank you.
We appreciate your attendance, and really on behalf of the law school, thank all of you. I want to make it clear that the student editors of the MJLST get a great deal of credit for this program. My major contribution was doing nothing, which I'm very good at, by the way. I want to take just 90 seconds to try to put in context the panel that we're going to have right now, then let the experts talk, and try to set how it fits into the broader picture. The first panel talked about what I'll call the creative process, the IP, whether it's copyright, patents, etc., the creation. The third panel is going to talk about what happens when things go wrong. And what do you think about liability, product liability, other types of questions. What we're going to concentrate here is potentially the linkage between those, and that is the oversight mechanisms, sometimes constitutional, sometimes statutory provisions, sometimes regulatory. And as various speakers have alluded to, there are a lot of regulatory implications here. I happen to be an FDA nerd, so I think about the 3D printed knee, drugs, whatever it happens to be, and all the challenges it poses. At a higher level, the challenge in the world that we inhabit is that we are really good at regulating what happened yesterday. We're not good at regulating what's coming down the pike. And historically, we regulate after there are dead bodies. And so one of the things we're trying, I think, as a broader community, is to get the regulatory thought ahead of just thinking about the past and linking it more into the direction that the technology is inexorably taking us. So we're going to lead off with Peter setting the stage. We'll go through the panels and have a quick Q&A at the end. Thanks. Yeah.
Perfect. So, this panel focuses more on the regulation of the entire, what people call the next industrial revolution. And we've seen a lot of specific examples. Most of them are centered on 3D printing. So what I'm going to do at first is we're going to abstract that movement a little bit, and we're going to start to look at what's going on in a more broader context. Really, you can call all of these technologies computer-aided manufacturing, and it has an acronym which is CAM. It actually started quite a while ago with CNC, which is computer numeric control. So here, we saw earlier that this is a CNC mill. It's carving away subtractively. It came about in the 60s. In 1983, Chuck Hall invented stereolithography, which hasn't been mentioned yet today, but it is the precursor to 3D printing. And that was the first additive manufacturing process. It involved a liquid and UV light. And now we have 3D printing. So those three technologies are kind of considered the backbone of the revolution, but now we have these new entrants. DNA fabrication is one. We've had recently a device, very small and compact, able to do DNA synthesis very inexpensively. And now people are proposing chemical synthesis. So what are all these devices really doing? They are acting as an interface between information and reality. So they are the blue arrow at the top. And you can also go in the other direction. You can go from reality to information. That's generating a CAD file at the bottom. So just like the example we saw earlier where Mozart went into the Vatican and he listened to the song and he remembered it all and then wrote it down, he was essentially acting as that interface. People can do it when they model things directly. But now we have 3D scanners, which are also referred to as reality capture, and DNA sequencing does the same thing. It looks at something in reality and turns it into abstract information. Now, what's really interesting about this is that both of these two systems are getting better at mimicking one another. So on the information side, the more powerful computers become, the more fidelity and the more clarity and resolution you get. And that's very important. I was talking to Professor McAlpine about this earlier, and he goes, inevitably, we will need massive amounts of storage capacity to store all of the information required for what we want to print. And when I return later, I'm going to speak specifically about that because it has very long-term implications for regulation. So we've already seen some of the properties. These are the idealized properties of computer-aided manufacturing. They're self-contained little factories, so they're affordable, easy to use, widely accessible in our long-term vision, and it builds complete pre-assembled objects, and this is all happening in a decentralized context. It has exact information translation, and again, this is disregarding the sorts of manufacturing defects that can occur with the device, but if I have it specified as information, it'll bring it into reality through that interface. And so it can build impossible shapes, things of theory, things of mathematics, that only algorithms previously described. And that also eliminates physical uniqueness. I can print the same thing over and over again. It also allows for costless customization, and this is very key in the long term. Contextual creation. I want to make something for a specific context, and now I can do that. I don't have to have someone in a company look at the entire marketplace and say, this fits everybody moderately well. I can have a toothbrush that's meant to brush my teeth. And finally, once you have that, it destroys economies of scale, once you have that costless customization. So what's CAM's currently capabilities? It can build really small things. This race car is 300 microns. It can build really big things. Now we're to the point where we can do multi-story buildings. All wide range of materials. And we've had some breakthroughs in how those materials are worked with and combined. Multicolor doesn't sound that interesting today, but in the late 90s, when you could print multicolor, it was a big deal. Now we have gradient alloys that no one even knows what that means 10 years ago. You start with one metal and you slowly fade into an entirely different metal. So that has profound implications for metallurgy. and then multi-material. So you're going to combine different materials. Biological creation requires its own conversation because it has a rather unique property. So we saw 3D printers printing tissue earlier, but once you have power over DNA, you can not only build up from the DNA to cellular tissue to macroorganism, you can build down. You can, in other words, build a cell that will make an enzyme that will make your small molecule, whether that is heroin or whether it's silk. So now we're going to introduce something. This is kind of a thought experiment. It's in the same category as, like Schrodinger's cat. And it's the omnipotent printer. And this is something that can make anything that you desire or imagine. And we're adopting it for argument's sake. So any material, any scale, and anyone can use it. And by the way, it's free to produce something. This is, for example, Professor Langvardt used this in one of his recent pieces to thresh out constitutional issues. So let's practice using it real quick. It's already printing an elephant. Someone propose an electronic modification that you could do to this elephant. Anyone? Okay, I'll do the first one. Let's give it LED lights in the trunk, right? So just like we saw earlier, we're going to print the trunk and it's going to have these beautiful patterns of LEDs. Okay, now an inorganic modification. Someone has to do this one. Anyone? Oh, there.
Replace the material with tusks.
Okay, what's it made out of?
Metal.
Out of what?
Metal.
Metal. Okay, metal tusks, like Wolverine, kind of. This is like a Wolverine elephant now. So okay, we'll return to that later. So this is so contrast that with our core regulatory assumptions as a society. Things are hard to make. We saw earlier, people used to go to tradesmen, someone specialized in it, and then whole factories did it. It was completely dissociated from the consumer. Objects are trustworthy. It got vetted somehow, and they originate in factories. So the current disruption, as we've seen, is guns. So that has to do with danger. But there's also distrust, intentional mistrust. So if you look at paintings that can now be copied and then potentially sold as the original, this high security key in the corner is interesting. Some students at MIT copied that based upon a photograph of high security keys in the New York Times. Shocked everybody. And then over here we have, this is an ATM skimmer sent in to iMaterialize. It was luckily caught by them before it was sent back, but it was meant to install on the front of an ATM machine and steal card data. And then up next, as we saw Candace Cerisi kind of mention, foreshadow, is that we could have viruses, like global pandemic, coming out of a garage. That's the fear. And then along with that, bacteria that produce narcotics. So overall then, there's 5 regulatory choke points. She also brought up some of these. There's, of course, the actors, actions, and objects, traditional statutory regulation. There are the CAM devices themselves, if you're going to license them. There's CAD file use, putting essentially DRM on the device. And then there's CAD file distribution. So DMCA-like procedures and, we had a font change, internet surveillance. And finally, there's raw materials, but only if those materials are holdout materials that are still produced at a central location. So with that context, I will turn it over to Professor Thierer.
Well, good afternoon, everyone. Again, my name is Adam Thierer. I'm a senior research fellow with the Mercatus Center at George Mason University, where I research the policy implications of various emerging technologies. I've tied together a lot of the thoughts you'll hear today about these issues in a recent book that's coming out in its second greatly expanded edition in just a few weeks called Permissionless Innovation. And these are the topics that I cover at George Mason University that I have law review articles on or I discuss in the book in terms of the policy implications of these various emerging technologies and how there's a sort of an interplay between all of them. But obviously we're here today to talk about 3D printing and additive manufacturing and the policy implications. But in each of these areas that I cover and I write about, what I've tried to tease out is that there's a sort of conflict of visions or a contrast of paradigms that people often flock to when thinking about how these technologies of the future should be governed. And I describe them as permissionless innovation and the precautionary principle. And what I'm going to talk about here today in my presentation is which of these two visions should or will govern the future of 3D printing and additive manufacturing. So what is permissionless innovation? Well, generally speaking, it's a term of recent but uncertain origin. I certainly did not coin the term. It's unclear who did. But it generally refers to the idea of the sort of general freedom to experiment and learn through trial and error, to be open to change and risk-taking and even the possibility of failure, and to generally, as a policy matter, avoid prior restraint and to seek out some potentially less restrictive alternatives to problems before preemptively regulating or imposing controls on new technologies. Importantly, for purposes of this discussion, I want to draw some lessons from the Internet experience more broadly and talk about where permissionless innovation has sort of played out and how that's worked out for us, because the United States generally embraced this ethos of permissionless innovation for the Internet and for the digital economy more generally starting in the 1990s. Now, that wasn't always the case. This is a wonderful quote that appeared in the MIT student handbook in 1982 about the Internet, or when it was then called the ARPANET. And it said that for students it is, quote, illegal to use the ARPANET for anything which is not direct support of government business, and it's both antisocial and illegal, and it could get MIT in serious trouble with government agencies. So there was a time when the Internet was heavily permissioned and limited. It was just the confine of a handful of academic researchers and government agencies. But that all changed, and changed quite radically beginning in the early 1990s when the Clinton administration came in, and they started allowing the opening of the Internet, opening in many different senses, but first and foremost in a commercial sense, allowed commercial activity to take place over the Internet. And then a host of other changes took effect in Congress in the mid-90s, but really the forgotten element that I think is really important that the Clinton administration did in 1997 was what in my opinion is a brilliant document called the Framework for Global Electronic Commerce, which really set the tone for how our government would treat this new thing called the Internet and cyberspace. And it said generally that the Internet should develop as a market-driven arena, not a regulated industry. They didn't want to treat it like broadcasting and traditional media platforms. It said government should avoid undue restrictions on electronic commerce, that parties should be able to enter into voluntary negotiations, and where government involvement is needed, it should be, quote, predictable, minimalist, consistent, and simple legal environment was the aim. And that was really quite of a powerful document and vision, and I think it really had a profound impact on the future of the Internet and its success. It really, in my opinion, drove the explosion of Internet entrepreneurialism and free speech that we saw in the subsequent 2 decades, because nobody needed to sort of get the permission from anybody in government to go out and do the next great thing or say the next interesting thing. And it became a really powerful driver of the competitiveness, our global competitiveness. And I'm not going to bore you with all the details, but when you think about what permissionless innovation meant for the Internet, you can think just about the explosion of Silicon Valley technology companies. You know, there were only like 3 or 4 of those logos. Those are logos for tech companies in the Valley. There were only 3 or 4 of those companies in the 70s, and now there's an explosion of commerce there. You think about how American companies became household names across the globe. This is a survey of the 10 most innovative companies in the world done by Booz Allen and Company every year. And consistently, the 9 out of 10 most innovative companies in the world, U.S.-based and based in computing, software, and digital engineering. This is a 20-year snapshot of the sort of changing fortunes of tech companies with a lot of churn, but the important thing being that U.S. companies absolutely dominate this list of competitors. And then finally, you look at the contrast in a transatlantic sense, sort of the conflict between Europe in terms of their more heavy-handed top-down approach to regulating the Internet versus America's. And it's resulted in my opinion, in American companies becoming sort of household names across the world and in Europe, and the IPOs tend to reflect that. So you think about also just what it meant for consumers in terms of all the different services and platforms they have access to at a fairly good price, in some cases free. So that's a pretty good indication that permissionless innovation has a pretty decent track record, if you will, in helping to fuel free speech, entrepreneurialism, and so on online. But what about the downsides? What about the risks? What are the problems that ultimately lead people to advocate preemptive policy prescriptions? Or why is it that some people would still favor what is known as precautionary principle policies for the internet or other technologies? And what is the precautionary principle? Fairly straightforward. It's the idea of crafting public policies in such a way that innovators aren't allowed to move forward with their new creations until they can prove that they won't bring about some sort of harm. It's, if you will, sort of a better to be safe than sorry approach to sort of preemptively addressing potential concerns or theoretical harms. And what are the major fault lines in all of these technology policy debates that I highlighted in that first slide? Well, I think there are these 5 areas that I group it into in my work, which is the first being privacy, the second being safety related, and that's a broad category, and we'll talk about that more in a moment. Third being security, fourth being economic disruption, and the fifth being, of course, intellectual property, which I'll also mention briefly in a moment. So this conflict of visions, I argue in my work, is really evident in all of these different technology policy debates, and it's going to be evident in the world of 3D printing. You have this different contrasting worldview of like how we should treat innovation. Should it be carefully guided, or should it be more freewheeling? Is our goal stability and equilibrium, or is it spontaneity and experimentation? Are we going to anticipate risk, or are we going to try to adapt to it? Are our solutions going to be ex ante, or are they going to be ex post? And so on and so forth. And regardless of where you stand, there's a sort of a spectrum of views you can think about. And this is how I've tried to put it all together on one messy chart between precautionary principle and permissionless innovation, because we're rarely at either of those poles. We're usually somewhere in between on a sliding scale, although I would argue for the most part, with regards to most internet-based policy issues, we've started there with a bottom-up approach of permissionless innovation and thought, first and foremost, well, let's wait and see if people adapt. Let's see how they bring these new technologies or devices into their lives. Maybe then we move on to more of a resiliency-based set of solutions if we need to. But usually we don't start with the precautionary type of approach of trying to ban certain types of speech or prohibit certain devices or technologies. Now, what's important, and I'm going to allude to this in a moment, is that we do, however, have many different regulatory regimes and agencies that do begin with a presumption of precaution. Basically, any agency with an F at the beginning of its name, FDA, FAA, FCC, many others, often start with a precautionary approach to innovation policy, saying, first come to us, get our blessing, kiss the ring, mother may I kind of thing. And so this is the tension, again, that I argue is evident in all these debates, and it's going to be evident for 3D printing. Now, what's the problem with precaution, or permissioning innovation, if you will? And I think it comes down to this, and this is what I argue in my book, so I just show you my hand and so you know where I'm coming from. You probably already guessed it. But the problem with precaution is that if we spend all of our time premising public policy upon hypothetical worst-case scenarios, then ultimately a lot of best-case scenarios will never come about. And that ultimately sometimes you need to allow for that experimentation and even, yes, some risk and failure in order to prosper, in order to move forward and to learn. So my bottom line argument for all of these technologies is that generally what was good for cyberspace is good for meat space. That's what's good for the world of bits is good for the world of atoms or the industrial economy, and that the general policy default should be innovation allowed, including for 3D printing. But again, what about those potential risks? Because we should be clear, there are certainly many risks, including risks with 3D printing. So this is a big whiteboard that hangs on my, a picture that hangs on my whiteboard in the office. I'm sorry you can't probably read all the fine print. It takes all of those policy fault lines, it takes all of the technology issues or sectors that I mentioned in that first slide, and it tries to weight like relative sort of threat vectors, regulatory threat vectors of like each area. What policy concern will ultimately drive each technology's attention in terms of the regulatory arena? And so highlighting 3D printing there on that chart, as you'll see, I argue, my colleagues and I argue, that it really comes down to safety and IP are probably going to be the two fault lines of the most importance in policy discussions about 3D printing. Candace, in her wonderful keynote address at lunch, already stole some of my thunder about some of these things, the firearms example, the medical device example of 3D printed prosthetics, and then there's the issue of toys and sculptures. These are the 3 case studies that I used in the article that I've submitted to the journal. And they're really interesting ones. I'll just mention this picture of this child from with the Wolverine hand. I was at Johns Hopkins University Hospital where they were doing instant replication of 3D printed prosthetics for children with limb deficiencies, and there were children who were requesting Wolverine hands and Iron Man hands, and they were being made on the spot. It was really an amazing day. and all these families were bringing their kids on a weekend to get them custom fitted there. And I was debating an FDA doctor about like, well, what are you going to do about this? Technically, kind of like a lot of what's happening in this room isn't clearly legal, but I don't think you'd want to stop it, right? And he's like, no, but we're interested. We're looking into it. And then the toys and sculptures issues. I don't know if any of you saw the article in the New York Times just 2 days ago about this particular bust of, I'm going to forget the name, Nefertiti, right? And the New York Times article was about how two Germans who were angry about the museum, I think, having that sculpture, went in with cell phones and scanned it and then reproduced it and made it widely available. And the museum was not amused. But it wasn't really clear what their claim was. It's a couple thousand years old after all. It's, I hope, in the public domain. But it became an interesting case study about how that's going to play out going forward. So, you know, Candace also alluded to this, and so did Peter to some extent. You know, there's these questions of like, where are the regulatory choke points, and how would you go about imagining opposing a precautionary principle mindset on 3D printing? Well, it's really, really difficult, right? If you think about it in the context of guns, medical devices, or these other reproductions, you know, are you going to regulate blueprints? And if you try, and I'm sure Kyle will talk about this, there are certain speech issues there. There's questions about, is that prior restraint in a First Amendment context? Are you going to license devices? Well, Devin mentioned earlier, these are general purpose technologies that are pretty hard to control and probably should be hard to control because they can be used for so many other purposes, beneficial purposes. And frankly, they're already pretty diffuse in society. You'd have to figure out how to lock down the ones that are already out there. And then what about controlling inputs, you know, plastics, metals, so on and so forth, or other things that are needed to assemble them later, like glue or wire or string or whatever. You know, it's very hard to know how you begin to go about controlling all of the inputs for 3D printing. And this is, again, reflective of our broader experience with the internet. It's hard to control general purpose computing. It's hard to control smartphones that are out in the wild with everybody. It's hard to control a lot of the different types of devices. It doesn't mean it can't be done. It just means it's challenging, and it should inform how we think about policy, is what I argue in my paper. What would a permissionless innovation policy look like for 3D printing, if you will? Well, I use a 10-part approach to sort of permissionless innovation policy in all of my work. And I'm not going to go through all of these. There's too many of them. But I basically start by saying, well, if policymakers are real about it and they really want to embrace the idea of permissionless innovation for new technologies or platforms, they need to first articulate and defend that as a policy prescription or a policy blueprint, just as the Clinton administration did for the internet more broadly. Our government needs to clearly signify to entrepreneurs that, you know, you've got a green light to go out there and innovate. We also need to think about identifying, removing barriers to innovation, and I'm not going to talk about all of these. I'm going to talk about the ones that are bolded here in just a second. But I think there's a lot of other interesting potential bottom-up solutions that I won't have time here today to explore about relying on existing legal solutions or other types of norms, contract law, property law. There's also independent certification and things like that. I just don't have time to get into all of these. But let me talk specifically about number 4, number 7, and number 8. Number 4 is about immunities and liability issues. And I don't want to take any of the thunder away from the next panel, but just this week I wrote a piece with this title about needed a Section 230 for the maker movement, where I advocate for robotics, for virtual reality, and for 3D printing, some sort of immunization regime to protect intermediaries from onerous forms of liability for innovative activities that happen on their platforms that may potentially have some risk associated with them. And I believe that there may be some need at some point to immunize some of these platform providers or device manufacturers in the 3D printing space from some of these forms of potentially punishing liability in order to encourage that ongoing life-enriching or even life-saving innovation. Do we have some models? I think we do. 47 U.S.C. 230, Section 230 of the Telecommunications Act of 1996 was probably the most important of all internet policies. It's a forgotten policy, but basically it immunized online platforms from liability for the acts of third parties who interact on those platforms. So you think about YouTube, you think about Yelp, you think about eBay, you think about all the different online platforms that probably would not exist if they were held liable for all of the silliness that other third parties do on those platforms, right? And Section 230 immunized them from those sorts of actions, whether it be of a defamatory nature or whatever else. But it's not necessarily the only model. We have the Protection of Lawful Commerce in Arms Act of 2005. This is, of course, quite controversial because this immunized firearm manufacturers from the many lawsuits that were pending associated with sort of downstream actions by third parties who were engaged in actions with guns that resulted in great harm. And people were trying to sue the makers of the guns, saying you should have known that they'd be used for these things. Congress preempted those lawsuits and said, enough of that. We're not going to hold the firearm manufacturers liable for what people do with guns out in the real world. And then the third model that not many people are aware of, in National Childhood Vaccine Injury Act of 1986 was put forth after a lot of vaccine makers came to Congress and said, look, we know you want us to produce more vaccines to help prevent certain types of diseases, but the fact of the matter is every time there seems to be even a hint that something might be wrong, we get sued. And if you want us to continue to make these things, which are pretty low margin types of drugs or immunizations, then you have to somehow help us out. What they did here was quite interesting and potentially relevant to 3D printing, because they said, okay, we'll create a no-fault regime, you won't be held liable, but people are going to have to draw from a fund, a vaccine injury compensation fund, if they believe that there's some sort of injury associated with the vaccine. So you might imagine that if in a world of 3D printing, if we immunize the 3D printing platforms or the device makers, the people design the blueprints or whatever else, there still could be resulting harms, right? How are we going to compensate that? How are we going to deal with that? Do we just say caveat emptor, buyer beware? You know, I don't know. Maybe we need something more than that. Maybe we need some sort of compensation fund. Would the 3D printer companies kick into it, or would it be generally funded out of taxpayer revenues? That's open for debate, but it's another potential model for how you can move forward and protect the intermediaries while also dealing with the harms. But here is what I think is the most important thing that is always forgotten in this and many other debates about technology, which is that if you believe technology is moving as fast as I've suggested here and that it's very, very hard to regulate, then at some point we have to get serious about education. We have to get serious about talking to people about the downsides of certain types of innovations and understanding responsible use of those innovations. And this is not just for kids, but it's for innovators, it's for all sorts of other parties. I've done a lot of work on digital citizenship and media literacy and health literacy. These are sort of the forgotten element of a lot of these discussions about ways we can talk to people, the public, to producers and everyone else about thinking about responsible uses. And ultimately, we're probably going to need to get to a point where the 3D printing community comes together, starts talking about best practices, starts talking about ways to have maybe third-party certification, as Candace suggested, or maybe even some sort of device approval in a more voluntary and formal sense. At a minimum, better labeling of devices and better explanation to the consumers about how to properly use them is going to be absolutely essential. I spent a lot of time talking about this in my law review article and in my book. So that's really, excuse me, that's really it. I'll just say that I talk about all of this stuff in my book. I hope you download it and read it. It's free. Or if you'd like, you can buy a copy on Amazon. And it's second edition coming out in 2 weeks. Thank you very much.
Okay, so I'm going to talk about the constitutional dimension in all of this, or as I see it, there isn't much of a constitutional dimension, or there shouldn't be. I take for granted that the government is going to have some interest in regulating 3D printed goods, and we've already heard about choke points. The basic problem of regulating 3D printable goods is that there aren't any of the usual physical choke points, factories, warehouses, distributors. Instead, the only viable choke points are going to be the files themselves. You can try to suppress the availability of the files, or you can go with some kind of DRM scheme. Now, the type of measure that's regarded as First Amendment problematic is the suppression of the files themselves, and so I want to talk about that. The first point that I want to make, though, just preliminarily, is to address the objection that I anticipate some people might have, which is to say that it's simply going to be impossible to suppress these files. There's this saying that the internet interprets censorship as damage and routes around it. And you might think of Napster, you might think of the availability of copyrighted files. You can always find them if you're just willing to put in the time. But I think that if we say that the internet is completely unregulable and completely unresponsive to regulation, simply because it's possible to go and find these files if you put in the effort, then by that measure, any kind of regulation is futile. Regulation never establishes any kind of hermetic seal. Instead, what it does is it attaches cost and annoyance and frustration to the type of activity that's being prohibited. And by that measure, I do think that the internet is meaningfully responsive to regulatory pressures. Think of the Digital Millennium Copyright Act. If you go on YouTube and you want to watch Better Call Saul, right? You want to pull up the last season of Better Call Saul. It's not on there, and there's a reason for that. It's called the Digital Millennium Copyright Act. The Digital Millennium Copyright Act applies pressure to a certain kind of choke point, which is what I guess the statute calls an internet service provider, though that usage is archaic. Today we'd say platform or something like that. It applies pressure to an officer at YouTube who is bound to comply with any kind of takedown notice. And it really works. If it didn't, nobody would subscribe to Netflix. So I think it makes sense to assume that the government is going to at least try to suppress certain types of files. Now what are they going to try to suppress? Well, I would assume that the government's regulatory priorities in this area will be the same as they are with traditional manufacturing. So unsafe toys, guns, we already know about that. Someday, drugs, I suppose, bad bicycle helmets. We've heard about all kinds of designs that might pose some sort of danger to the consumer. Now, okay, how does the First Amendment come into all of this? Well, here's how the argument goes, and, well, you don't have to trust me. You can look up the case. It's called Bernstein versus Department of State, and it goes back to 1996. When I summarize the argument for First Amendment protection, you might not believe me because it's so stupid. But this is, I mean, to me, this sounds like the sort of argument you come up with in your dorm room before you go to law school or something. But the argument is that code is a language, that people can use computer code to exchange ideas with each other. And that's true. I'll concede that that code could be a language. I'd even be willing to concede that machine code might be human readable at the limit. That's fine. It's the next step that's really problematic, which is to say that anything that's written in any kind of language amounts to speech for constitutional purposes. That might sound initially appealing, but if you really think about it, actual spoken speech is not usually speech for constitutional purposes. I mean, imagine that you and I have a contract, and I breach the contract, and I make the argument in court, or my lawyer makes the argument in court, that, well, I used language to make this contract. And so if some kind of legal penalty is going to attach to that, if my use of language is going to be burdened by this contractual obligation, then that imposes some kind of constitutional problem that we're going to have to grapple with, right? We're going to have to apply the First Amendment in this case. Or say that insider traders say, all we did was exchange information with each other. Information is speech. The First Amendment's implicated. You at least have to go through a First Amendment analysis. Speech in furtherance of a criminal conspiracy. So you've got the petting zoo, right? You go to the petting zoo. The state has a law saying that the petting zoo has to have a sign saying, don't feed the animals, or don't pet the animals, or something. These laws exist. No one makes the First Amendment argument. And the reason they don't make the First Amendment argument is not just that they would lose on the First Amendment merits, it's that the argument is so frivolous and ridiculous that it would be sanctionable. So to my mind, it overextends the coverage of the First Amendment considerably to say that all uses of language are speech, even if we're talking about plain language. Well, at any rate, that position expressed in Bernstein is today a consensus position. The Supreme Court hasn't ever handled one of these cases, but there are, by my count, 9 lower court cases that purport to apply this standard. They at least recite the mantra that code is speech for constitutional purposes. Well, so that brings us to 3D printing, and you can see where this is going. You print from a CAD file. A CAD file is a list of Cartesian coordinates. It's a description of a shape. Or if you want to look at it in some kind of reader, it's a picture. And so we see the argument in the defense distributed litigation, this is the 3D printed gun case, that all this case is really about is a picture of a gun. This case isn't about guns at all. It's about pictures of guns. And we've got thousands of cases telling us that pictures are fully protected. And it gets worse. I mean, this is language from the actual brief. This is extremely pretentious, I think. They say this picture of a gun, this CAD file, is speech concerning a constitutional right. Well, sometimes it's hard to know how to argue against a position that's that intuitively bizarre, and I never feel that I can quite adequately, but it's hard for me to know just how seriously I'm supposed to be taking it. Because if we do take it seriously, what it leads to is a regime in which you're going to apply strict scrutiny, the highest scrutiny known to American law, to virtually any kind of product ban applied to 3D printable goods. I mean, there's no way around it. There's two reasons. First of all, if you try to suppress the file, then that's going to be regarded as a prior restraint. We see the blueprint for this in the defense distributed litigation. Prior restraints are like the greatest evil known to First Amendment law. It's like the operation of the censor or the licensor. And then at the same time, if you are suppressing some goods, some pictures of some things, but not pictures of others, then you're discriminating based on content. And if you're discriminating based on content, that also gets you to strict scrutiny. Now, where does that lead? Well, I suppose if we really take it seriously, if everybody really believes this stuff, that we're talking about speech about constitutional rights and viewpoints, and that CAD files are primarily ways for visionaries to exchange big ideas, that's what it is every time somebody downloads a CAD file, then we're going to end up in a position where this stuff is completely unregulable and we go back to the Lochner era. Now, I don't think for a minute that that's what's going to happen. What I think is going to happen, and this bears out in the cases that exist about computer code, is that judges will continue to recite this mantra that code is a language, language is speech. We have to consider the First Amendment in all of these cases. But they're never quite going to believe it. They're going to know that they're basically dealing with cases about commerce, and they're going to give government, in effect, the same kind of latitude that they always give the government in cases about commerce. And so what they're going to do is they're going to look for watering down mechanisms. This is what's happened. I've counted 9 lower court cases that apply this code as speech language. This really high-flying language. It'd say that any case concerning computer code has to concern the First Amendment and so on. It's only in the first 2 that the First Amendment challenger actually wins. In the next 7, the First Amendment challenger loses. And I can get into more detail about this later on, but that might be outside the amount of time that I have. The device that they use to uphold the government regulation is a device known as secondary effects. I don't know if anybody is a First Amendment scholar here. This is a known watering down device that normally is only applied in cases involving nude dancing and adult bookstores. It's a workaround, and everybody knows it. And I'll tell you, in the defense distributed case, the same thing has happened. We've seen the secondary effects doctrine applied again. And here's what's really remarkable about it. Not a month before this first opinion in defense distributed came down, the Supreme Court pretty clearly had taken that device off the table. I mean, you can tell that the court was just desperate to find some way to water down the law. Well, I guess here's my position. To me, coming up with a Lochner-esque 3D printing regime that's based on free speech is bad in the first place because it's Lochner. I view Lochner as a bad thing. I know Lochner has its fans. But even if you are a Lochner fan and you'd like to see the Supreme Court sit as a board of policy on economic and commercial matters, I'd say this. You're not really going to get there. You're going to get this high-flying First Amendment language that's not really going to drive the outcomes. You're not really going to get freedom of contract. And what you are going to get is a lot of watered-down, intellectually incoherent First Amendment language that over time, I think, is likely to seep into cases involving more traditional First Amendment rights. If we see courts apply watered-down versions of the strict scrutiny standard in cases involving 3D printing, I think there's a substantial risk that that watered-down strict scrutiny standard will eventually migrate outward to cases that really do involve speech. We tend to be awfully confident of the strength of our First Amendment liberties in this country, but as we know them, they're fairly young. They've only really existed since the 1960s. And they're fundamentally counterintuitive positions. These things can change. And so I wouldn't, I think, risk their credibility on what I view as this frivolous and wasteful venture. Thanks.
So what we heard from Professor Thierer was there are, regulatory mechanisms. What we heard a little bit from Professor Langvardt was there are limits on those, potentially constitutional limits, and also there's consequences of adopting those. So let's return and then let's look at the long-term prospects for this new industrial revolution and what it means. And we're going to return 1 second to the omnipotent printer. This time it's making a whale. And you'll notice that there's a little bit of a problem with all of the, well, you won't notice it yet until I point it out, I think. But all of the things you've seen today, all the things produced by computer-aided manufacturing, have all been things of our prior experience. They all somewhat reflect our 5,000 years of manufacturing experience that we've done as a culture, a society, as a planet. That is going to fundamentally change. And the problem is also highlighted, for example, when you watch Star Trek and they have the fabricator machine supposed to be able to make anything, and Captain Picard approaches it and he asks for a cup of tea. Why isn't it more creative than that? That's one of the reasons I asked you to propose modifications to what's being made here. But even the modifications that we suggested are things of our prior experience. So the development of computer-aided manufacturing from here is going to be moving from phase 2 to phase 3. In the first phase, which was since the development of the technology kind of to its introduction as a consumer technology, it built prototypes. These were usually plastic or resin. It was one material at a time. It was one scale at a time. And it was, about 1 millimeter to a meter. And the flavor of that was novelty. In phase 2, which we're currently in, we are now producing finished products. And, it's made of metal and composite. There's 2 or 3 materials being combined at one time. And it's also covering a couple different levels of structure of the hierarchy of matter. So you might have microstructure, and then there's bigger structure, kind of like the Eiffel Tower is built. And the flavor of that is that these things are useful, and some of them are also concerning. Eventually, we are going to move into a third phase, and this is advanced innovations. And we are going to see chimeric things, like the thing that we made the omnipotent printer make. It's going to be a combination of biology, inorganic, and electronics. And we were very lucky to have the professor from Minnesota speak earlier, because he showed that that's possible and it's happening. There are going to be thousands of simultaneous materials combined with thousands of levels of structural organization. And the flavor of that is going to be wondrous and is going to be frightening. So I'm going to highlight two aspects of that future, two aspects that I've written about. And the first one is materials. So the things we're going to see coming as we've started to see are gradient materials. And that anytime you have a gradient, you have infinite shades of possibility. That means that you can make materials that are tunable to a particular environment or context. So for example, there are a bunch of lattice structures that are being produced in plastic right now where you can exactly determine the padding that you need for a given application. Another is that those materials are going to be responsive and adaptive to their environment. And this is known as fourth-dimensional printing. It doesn't involve tesserects or any real fourth dimension except for adaptiveness over time. And then, of course, like we mentioned, chimeric organisms. So what are the challenges of that? Well, any time that very low in the stack of the hierarchy of matter, you adjust something, it can have profound consequences as it ripples up that hierarchy. So we're going to start to see emergent properties come out of very low-level modifications based on our control using computer-aided manufacturing. Also, we're going to start having a hard time distinguishing between raw materials and products, because these devices are going to be chained together. The output of one product is going to form the input to another. And together, collectively then, that body moves closer and closer to the omnipotent printer, even if one device will never be able to do it. And for regulators, that means there's going to be taxonomic strain. In the Industrial Revolution, when product liability and regulation came about, you had a batch number, you had a company, you had a date of creation. Those things no longer exist. When you can have custom materials and a million different configurations, it becomes harder and harder with legislation to define what you're trying to regulate or even find its bounds. So we're going to see a shift towards functional descriptions of what is to be regulated, very much like patent claiming works. And there's all kinds of dangers in that, very similar to patent law. Now, the other side of it is computation. And the connection is not immediately evident. It takes some explanation. So I have bad news for a lot of people who are really excited about 3D printing, and it's that hardware is not the long-term story. If you look at the Gutenberg press, or you look at the Xerox machine, or you look at the laser printer, all of these devices stimulated a lot of discussion about intellectual property, a lot of concerns about how the economy was going to change. But in the end, they all fell into our ordinary technological repertoire, meaning we use them without really a thought. However, if you think about the things that these things produce, they have remained just as interesting to us today, the information on the page. So something printed by the Gutenberg press, you don't really care how it's printed. It's still interesting to us to read that today. The same is going to be true of 3D printing, is that the long-term story is information, CAD files, and the process by which those CAD files are created. So now that customization is free, you can create objects for any context. Now, if I'm building a custom toaster for my kitchen, that process is really easy. I measure the little nook I want to fit the toaster into, and it says 4 inches, and now I know the context. And I resize the printer in my CAD program, I print it out, stick it in the nook. But that's only the beginning. In the future, and we're moving there very quickly, we have to simulate the context in which we are going to apply this print that we're going to do. And that's why I asked the question earlier about what, within the scientific process, what role simulation played. We also saw that it's playing a role already today. So, for example, I have a car engine that is going to be printed out, but I want it to have the best characteristics for me. I am going to say, well, these are the types of roads I drive on. These are my favorite off-road trails. This is my environmental stance and my tolerance for pollution. And this is my daily commute. And that printer is going to be made for me. And if we go back here for a second, these three phases actually demonstrate that we're moving there. Because in the first phase, right, we've heard a lot about pegs and holes today. So in the first phase, we were saying, oh, this technology is really cool. Here's a round peg, a round hole. I can print a round peg for it. But we were too afraid to put it in. In the second phase, we say round peg, round hole, and we put it in. In the third phase, there are going to be no pegs and there are going to be no holes. And if you don't know what that means, I don't really either. But what I can tell you is that rods and cylinders in a car's engine are shapes of manufacturing convenience. And that engine will probably look like a lot more like a heart and a heart valve than it is any shapes we have prior experience with. So a printed object is only as good as its CAD file. There's a direct correlation between the time that you've spent simulating that context and the processing and memory required for that. And so the long-term story is the process by which CAD files come about. That means that computation and 3D printing and other CAM technologies have this inextricable link between them. Now, this comes at a fascinating time because supercomputers that used to apply these very heavy simulations traditionally were only owned by large institutions. Well, just at the same time that 3D printers were hitting the consumer market, Amazon came along and they said, hey, we have all this spare capacity for running our global e-commerce business. When it's not being used at full capacity, let's rent it out. And suddenly anyone with a credit card could rent as many servers as they wanted and run any sort of workload on it. And that's people like you and me. So just as 3D printers are getting distributed, so is the power of computation. So once you can create something for any context, what are the regulatory challenges of that? Well, if anybody specifies a particular part of their legislation, like guns are a great example, the barrel has to be so many inches. When someone is simulating the context, they just include that part of the regulation as variables to be simulated around by the simulation. And they can move vastly faster than regulators then. What happens when you can build so carefully to a context? And there is Professor Haxel who works with Autodesk. He proposed in an Atlantic article that in the future you'll be able to make a virus that is targeted just to one person. And you can release that in the entire United States. It will make no one sick and no one will know they will have it, and it will spread until it finds that one person and kill them. And finally, once all of these 3D printers are connected as part of the Internet of Things and they're producing things, they are going to be hacked as well. The viruses and the hacking attacks that come into large organizations today are going to make it into those CAD files. So we have an explicit example of that. This is the process in which CAD file will be generated in the future. You're going to gather some data. You're going to run a simulation. You're going to get the CAD file for a particular context. The raw material then gets sent through the 3D printer and makes a physical object. Well, a malicious code or malicious structure could make it into any of these areas right here. And just like Candace was saying earlier, where there could be defects in the manufacturing process, these are strategic flaws put in. and they will make it into the physical object, and they will cause it to fail within a specific context. So we can therefore really add a 6th regulation point, choke point in the future, and that is cloud supercomputing, because that is going to actually allow computer-aided manufacturing to make it to its top level of power. And that is a very interesting regulation point, because we saw earlier someone proposed that the PC was about decentralization. Well, as 3D printers have taken manufacturing and pushed it out and decentralized it, supercomputing is gone in the opposite direction and re-centralized the resources into data centers. So this actually remains a viable regulation point in the future. And so there's a lot of concerns about that. I mean, because if we do want this permissionless innovation, we're going to have to, free ourselves and allow people to have the power of supercomputers. So that specifically brings up then, based specifically around materials and long-term computational power, how does permissionless innovation play into this? Well, anytime you have emergence at a very low level, it means that the modifications that you make propagate all the way up the chain. So you have to be very careful when you regulate something at the fundamental nature of matter, or the building block for other things. Second, cloud simulation is a form of trial and error, and that is what permissionless innovation is all about. This is rapid trial and error. So very important to allow that to be free as well. And finally, democratize research in this vast new field. The more people that we have experimenting in this area, the more innovation is going to come out of it, because we do not have enough researchers, we do not have enough formal university support to ever catch up to the amount of potential that's out there. So thank you very much.
We're going to have just a couple of minutes here for questions. I have actually a couple hundred, but we only have time for 2. And then we'll have just a couple of questions from the audience. Let me ask a fundamental question. I'm going to use the word here regulation to mean constitutional, statutory, regulatory agencies, the entire panoply of tools. Can current regulatory structures appropriately handle 3D printing challenges going forward?
That's for you guys.
Oh, no, you're part of this. You can't escape.
Well, it's not clear to me which regulatory structures apply to 3D printing. There are certainly some that might, by extension. For example, you deal with field medical devices, and the FDA is already well aware of 3D printing, has looked into this, and it's, instead of trying to apply a traditional sort of top-down command and control playbook of medical device regulation to 3D printing, they've taken a more flexible approach, thinking about best practices, convening various parties in the field and experts. And I think increasingly that sort of model of sort of multi-stakeholderism and industry guidance and best practices is going to start to catch on. We see this happening in a wide variety of other fields, from biometrics to big data to Internet of Things and wearable technology. Increasingly, regulators are saying, we know we can't keep up, that we can't keep up with the pace of technological change, and therefore we have to take a more flexible, adaptive approach. It's also unclear how the existing regulatory models apply in a lot of these cases, and for that reason they're trying to sort of make it up as they go along. I think the challenges that we talked about here are still very relevant, though. It's unclear to me what's the point of attack? Where do we impose liability? Where do we ask for control? Where do we stop things? Could be supercomputing level, could be at the servers, it could be large intermediaries, but in a world of truly decentralized, democratized innovation, as we increasingly see in the world of 3D printing, it's harder and harder to find those choke points, which is why I alluded to the fact you have to think about other bottom-up solutions, whether they be educational related, transparency, labeling, certification, other things like that, which aren't perfect, and there's a lot of holes in that model, and a potential for some serious harms. But I don't see how the alternative model really works.
Peter, any other thoughts?
Well, now this isn't, I'm not talking about the advisability of doing any of this, but I guess I didn't bring up, I could see a DMCA type model. I think in a lot of ways what's gone on in the defense distributed case, this involved ITAR, the export of weapons. It looks like a clumsy early stab at a DMCA type approach. And then another approach, and I sometimes kind of feel like I'm like working the dark side when I talk about this stuff. But you think about China and its Great Firewall and the Golden Shield. I don't know if people are familiar with these things, but if you go to China, the state has managed to police subversive language extremely effectively. There was a Reporters Without Borders report, I think, about 10 years ago. This is in the book Who Controls the Internet by Tim Wu. Apparently you use blacklisted language and it just doesn't appear on a message board. So they'll have Cisco routers installed at various choke points. There are a number of high-level routers that regulate information coming into the country, and then you've got corporate ISPs. So you've got automatic filters, and then you've just got a huge police force. It seems to be at least feasible, and so I could imagine those same tools being used someday to suppress illicit designs.
But Kyle, do you think that's practical in the U.S.? In China, clearly yes. Maybe even in Russia and a few, Middle Eastern countries. But realistically, the sort of genie's maybe out of the bottle, or regardless of the constitutional issues that you discussed. I mean, practically speaking, the sort of means of production in this context are so highly decentralized. What's so effective about the Chinese system is how they've kept it more centralized and controlled its centralized sources. I would think that model, while maybe working in some countries, not going to work as well here.
Well, it might be that it's a policy matter. It's a bad idea, and I'm not addressing it at that level. But
right, practical.
The technical architecture, I don't know that the differences would be dramatic.
Okay.
One or two questions from the audience, then we've got to break for the next panel. All of you trying to figure out what the heck this means. Then I give maybe the last question. We seem to be bouncing back, and the we being everybody, between thinking about regulation at a product level, in my world a medical device, a drug, other people's, an airplane part, versus a process regulatory approach, supercomputing, whatever it happens to be. Is there an either or there? Is it a both? Do we look at this as a product-centric regulatory question or as a process-centric regulatory question?
I think it's actually both, because like take the supercomputing example. That is used to generate the initial CAD file, and there is a process around that. But once that CAD file is generated, as long as someone else wants to use something in the same context, then it starts playing according to the rules of traditional information moving around the internet, because you already have the information specified rather than going through the process to make it. So it's going to be both sides.
All right, anything else? Otherwise, we will bring up the next panel and thank the three of you very much for creating a lot of thought and work for us. Thank you.